Hello, this is a judicial branch interview questions that I was supposed to send to you like 2 days ago, but I didn't. So now I'm just gonna do them. So it's going. I'm just gonna give you, I guess, 1 through 16 because it's kind of in a predicament where I'm supposed to be in the bed, but I gotta finish this. So what comes first? I'll just sleep during church or whatever. The first question on here was, what are the three basic functions of the courts? We're doing 1 through 6, and then I will be done. So it's to settle the controversy through principles of law, to settle specific financial, not specific financial, specific factual circumstances, interpret legislative enactment, and determine constitutionality of the laws. Okay, question 2 is, how do courts set their expectations of fairness, and how do they benefit society? It is by having a jury to be by their peers, and let's see, it makes it, I guess, a level playing ground, because if they're by your peers, then they won't, I guess, go against you. I guess that has something to do with it. But I guess that would be my answer for that one. Number 3 is, in which courts do most legal actions occur in the United States? I'm going to say that would be the federal court, because that's where you have, in federal court, they basically deal with everything from like federal courts with it. Federal courts. And then number 4 is with examples, I guess. I think that's what number 4 is. What are the 4 main characteristics of federal courts with examples? They're separate from another. They are higher, or then with Supreme Court, they are able to use judicial review and are appointed for life. Those are the 4 characteristics that I got, and I guess those are just, I don't know how you would give examples for that, but those are the 4 main characteristics. Okay, number 5 is explain judicial review, and judicial review is like the way for a judicial branch to declare a bill to become constitutional or not. Number 6 is, what is judicial independence important? It's important because it separates like the judicial branch from all the other branches of government. So basically the only one who can judge the judicial branch is the judicial branch, which is kind of a problem, which they say, because it really goes against the separation of powers, because everybody else is supposed to respond to the courts, but then the courts only respond to the courts, if that makes sense. Number 6, my answer was, I already answered that one, my fault. Number 7, my answer was, they can make laws by, starts in the judicial branch by declaring it constitutional or not. I'm going on to objectives too soon. But now we are on number 8. I will give you the answers for 8, 9, 10, 11, 12, all the way up to objective 2. My answer for number 8 was person who serves before another, or I guess, yeah, the person who serves before somebody else is the precedent. The common law is an idea that says that a court's decision is set on a precedent for that constructure of the future to the future courts. My answer for number 10 was federal courts. Court system, original jurisdiction, law and order depends on the common law, which have appeal courts, where you can present yourself before a federal court, but they only take that if there's something specifically wrong with how they viewed that case, which would be if they, for instance, if they violated your freedom of speech, or if they, take away your referendum rights, or something like that. That would be an appeal court. The answer for number 11 was that it would be the process in which the courts can basically determine your case. Okay, number 12, the common law I said was common law was written for legislature, prosecution versus defendant. Public is criminal case in which a person has to commit a crime, and then civil is that involves a contract or agreement to settle. Number 13, it says what are the 3 types of laws? I've said that already. Civil, common, and criminal law, which civil, I said that they have to do with money settlement. Like I said before, criminal has to do with crime person commits. Common is based off of what the English court system and was passed down. So, number 14 is who are the parties. That would be the suspect, the victim, defendant, prosecutor, the defense lawyer, and the judge and jury. Number 15, it says how is the civil law different from criminal law, and which of the most fundamental rights are at the risk in civil law. I guess I would say 15 is different because, well, first of all, civil law is different because it's based on settlement of money, and then the criminal is dealing with the criminal act that you have to commit. So, and then, what was the second part? Let me go and find it. Oh yeah, which is the fundamental rights are at risk. And civil case, I guess it would be your it's the freedom of speech, but because no, when you feel it should be a freedom of civil. Yeah, freedom of speech, yeah. That's all. But I don't really know why that would be the case, but I'm pretty sure it's freedom of speech anyway. Number 16, I guess it would be a system where it is divided into state and federal and local courts, which are represented by common law and have to deal with outcome, and then they go from lower to high courts by bigger courts and with the outcome. So this is objective 2. I'm just going to read the answers that I got So basically, like, everything that I wrote down was from my head. So this is how I would answer the question, basically. So I guess my answer for objective to part 1 was that district courts have original jurisdiction, and that a district for number 2 is a district court is a stable, not stable, is a state of a federal court which deals with common law and has 2 per state. And I think it said in the video that it was like 12, so I might be wrong. So number 3, I said the appeal goes to believe that it's decided whether you can go to trial and see if you're able to commit or surface your case, which basically has to deal with what I said on section 1, which was that your freedom of speech or something like that has to be violated in order to do that. But the decisions of the appeals court are based on state region because of the state laws. Number 5 is which cases do they have jurisdiction over? They have cases that have to do with money or criminal or civil law, so they basically have jurisdiction over all types of cases. Number 6 was describe the process in which a case goes through the federal court system. Basically, I think I might have described that on a later question, but basically it goes to the way that, where is this? Which a case goes through the federal court. Well, first of all, you have to have a writ of some sort, and that goes to the pile of like but 50 court cases, and then they basically go to that one guy who's the, I don't know what they call him, but it's like, I don't know what they call him, but hold on. Look at my notes real quick. It would be the Solicitor General, which decides if your case can be heard in the Supreme Court or not, and then if it goes past him, they can basically a pool, and they say, okay, this law is important, and then you basically fill out 2 briefs from each side explaining why, like, what your court has to do with it and all that, and explain why you think that this way is right, and then why you think that this way is right, and then you turn that in, and then it goes into a pool, and then they vote on it by the judges, and then you actually get your case sent to the Supreme Court. So and then in West, it's the Supreme Court have original jurisdictions. They have jurisdiction over cases that involve ambassadors or consuls or public administrators. The answer to number 8 is if the methods are not tried or true with evidence, etc. So that's why there's an appeal court. Does the Supreme Court have to make a decision? I said they don't, or most of them, but they must have, I guess, mootness, standing, or ripeness, or some type of ruling. Mootness is a case that doesn't really need a court case for it. So like it's basically a case that's dead. Like if like a cold case or something like that. That would be basically the same thing as a mootness, I guess. Number 11, the political question of doctrine, I think, is one of the 4 views that the Supreme Court will view a case. That was answer number 11. And then number 12 is why will the Supreme Court hear cases that have a circuit split is to settle it and can dispute over other means. So basically just to settle it. That's all I could get from that. Like I said, I'm not really an expert on the judicial branch, so like this is all from my head. It's like I watched a whole bunch of videos, but it was what I got. So under the 3, I guess my answers were for number 1 was it's a document that allows the Supreme Court to view a case that comes from a dispute as a case, basically. The Solicitor General is the one who decides if the case should be heard in the Supreme Court or not. For judges to actually hear your case, you have to have called granting certiorari. Only 4 out of the 9 judges have to agree to hear your case, which is the rule of 4. Briefs are the petitions that have to be submitted by written legal arguments that explain why your law favors a position the party briefing. Number 5, the petitioner is a person that overturns the lower court decision, and the respondent is the party that wants the court to uphold or affirm the lower court's decision. So there you go. Number 6, historical arguments sometimes change the outcome of persuasion and contain different legal, economic, or affirm their legal. I can't read that. Legal, I guess, or affirm their opinions. They can also, one way that disputes can influence the decision of the Supreme Court. That's number 6. Number 7 is during oral argument, both sides ask questions about their opinions of their side of the case, which is, it's like basically having, I guess in the video it said that it's like basically having 20 different teachers asking you 90 different questions about why you think that you should get an A on the exam, on their exam. So it'd basically be like that. Which, no, I'm not doing that. Now, this is objective 3, by the way, so just saying. Number 8 is I put holding, but it could be judicial review because I was kind of in between those two. So, on number 9, I got a 5 out of 9 majority must agree on at least one of the legal arguments that affirms or overturns the lower court decision, which is the punt. Get it? Punt, like fiddle. The most important are the parts holding. Reasonable rationale behind the holding. That was number 10. And then number 11 was to dissent opinions are important because it's the concurrent of the rights by a single judge that are important because the lower courts don't have to follow it, but it can also favor or challenge decisions based on a case for supreme decision. And number 12, I just put they don't follow any of them. Okay, we're on objective 4, which is about judicial review, and that's one of the most important powers of the Supreme Court to declare a law constitutional or not. There's many different other variations of that definition, but that's what I got. Number 2 on objective 4 was presidential actions, state actions, supremacy laws, federal bureaucrat agencies, and congressional laws. And the question to number 3 on objective 4 was yes, by actions by supremacy clause. And then on number 4, I guess it would be the Judiciary Act of 1789, because that's what they said in the video was the main impact of that. Or actually, that might be an answer to something else, but this is objective 4, objective 5. I might have objective 4, so I guess that's what I got for that. Number of slides. This ideology influence how I said it does. I might have put number 5 as number 4. Yep, I did. Yeah, so, my bad. I put number 5 as number 4, so just bear with me. It's all going to be jumbled up. So, Congress can pass new laws, history, principles of decision, executive branch, and political ideologies. Party affiliation. Number 2 and number 5, what impact does have on the Supreme Court? Not much. Let's see, number 3, question 3, objective 5 is the constraints. The idea is that the judges should pay closer attention to the president when they make decisions, and that any changes that are made to the Constitution or into law should be incremental. Number 4 is the decisions are based on the Constitution first and then can be, I guess, added to. Number 5 is basically yes. It's based on basically your party affiliation, because there's ideologies in every party. So like the Republican Party believe in this and that, and based off of what your party believes in, and that's how you're going to, I guess, judge certain issues. That's why people say that like our, I guess, Supreme Court is basically imperfect judicial system, because like they are basically like, they're basically viewed as basically like perfect people, but they're not, because they are, some are picked by the Republican side, and some are picked by the Democratic side. So depending on what side you pick is how you're gonna vote. That's what I was doing on number 4. I'm going back to objective 4. I was basically always objective 5. Objective 4 said, I guess it would be the stare decision, which is the full lettering of the decision to stand. That was question number 5. I might be getting these questions wrong, just bear with me. Question number 6, I used Brown versus Board of Education, which they ruled that the colored races were not equal to the whites, even though, like, they were both places, but they weren't equal in, I guess, cleanliness or it'd be in education. Some places, or stuff like that, it wasn't equal. It was separated, but it was not equal, so they overturned it. Anyway, number 7, I guess, it comes from the Judiciary Act and the case of Marshall. No, not Marshall, dang it. Mayberry versus Madison, which, Mayberry basically made his rights of mandamus, unconstitutional, which went against his own party, which, number 8 was asking, how was that a smooth move, basically. It was a document that was supposed to allow Mayberry to get his job back from Madison, the Secretary of State. The thing was, it was brilliant because it gave the court rule that his job was supposed to be given to him, but his rights was unconstitutional, which also made it favorable towards the other party, which made Jefferson even more credible, and basically made him less credible, but also it illustrated that the Supreme Court was basically, at the time, very, I guess, weak, which, we got started somewhere, right? So I guess that's all that happened. And gained, number 10 was it gained the power by being able to change or strike down pieces of legislation. Number 11 it basically gives judicial. That was 11. I say it's a separation of powers because, like I said earlier, basically the judicial review is the ability for them to basically strike down a law. But if you're striking down a piece of legislation, then you're basically violating their freedom. Wait. It's separation of powers because, like I said before, like, the judicial branch can check everybody else, but the only person who can really check the judicial branch is the judicial branch. So basically, it's like I'm the principal and well, that's not a good example. Let's just say I'm the head or the dean of a college. The only person who can check me is, well, actually that's a false statement. Okay, I don't really know how to explain it, but like, It's basically they're the only ones who can check themselves. So yeah. Number 12 defines this. It's the decision that lets them make laws that can affect the laws of the future. Number 13, without a precedent, was the idea that allowed judges to make laws. 13 and 14 is allow judges to change the law based on, let's see, the value separation of powers, and they aren't implied. So I just finished 14 and basically 15. No, not 14 and 15. Shut up. I finished 4, 1 through 6, 1 through 5 of this thing, and then number 6 I got number 6 is easy. It's like it says how a federal judge is chosen. They're chosen by the president, or they're chosen by the president. The qualifications to be a juror is a term of life, and you have to be a born citizen, and you have to be above a certain age. And I don't know what that age is. I don't know, because I didn't put that really in my notes. So, but I know you have to be above a certain age. I just don't know what age that is. The informal qualifications are, I don't really know of any informal ones. I don't know what you mean by informal, so I'm kind of confused on that question. Number 4 was, when will the president and senators want the same qualifications for federal judges? They will want it when impeachment, but I don't know why though. Explain confirmation progress for judges. Well, I don't really know. They're I know they're picked by the president, so yeah. And how does the selection of the judges impact the legacy of presidents long after they leave office? Well, because the judges can't really be impeached, so, well, yeah, they can, straight that. But they basically have, like, if you're a Democrat and you get you get a Democrat to vote for a Republican, then that Republican could be that person that, like, goes against most of your laws, and so that could have a long-lasting effect on. So basically, the legacy of the president's actions between him and the judicial branch is the main thing that stays with the country, because that's where the laws are made, and when those laws are made, they can't be taken back. So, like in this election, you know, they did gay rights, they're working on gun control, they're working on all these other things. Well, the laws that are passing, they're not going to be able to at least take them away. Like healthcare, you can't really take that away because it's already in law. And I guess it's important to know judicial independence that's what separates the judicial branch from everybody else. They depend on themselves, like I said. So that's 1 through 7, I guess. So you get to 6, and I am now done. This is my video.